Hello everyone, this is Your Justice Now, and I'm your host, Harriet Clark. Today we'll be tackling real-life situations. Some of it may be shocking to you. We're going to be dealing with the tenant and the landlord, their rights and their responsibilities. This is serious business.
5, 10, 50, 20. Room for rent, supply within. When I run out, you run in. When I come 20, the room must empty. 5, 10, 50, 20.
We have some interesting revelations. We have some interesting facts. When we get back, it's Your Justice Now. Welcome back. Now we're here with Mrs. Marvelyn Taylor-Wright, chairman, or in this case, chairwoman of the Rent Assessment Board. Mrs. Taylor-Wright, thanks for having us. Now, the public, in terms of your average landlord, your average tenant, would like to find out about this organization. So, Mrs. Taylor-Wright, who makes up the Rent Assessment Board?
Okay, the Rent Assessment Board is a quasi-judicial tribunal. It also has administrative functions, and it has as its core, we have a body of persons drawn from the legal profession, from other areas of the society, who sit in management over the board as a quasi-judicial tribunal. Now, on a day-to-day basis, we have functioning between the board and the members of the public. Now, the board does not have the capacity to be dealing with that on a day-to-day basis, and so there's a rent services unit which has as its composite base all the persons who are statutorily required to cause the board to function properly. We have the secretary, we have the assistant secretary, we have the valuers, we have the inspectors, and we have the assessment officers, as well as the persons, other persons, the secretarial persons, the persons in the field. The director is the head of that unit, and basically pulls everything together to ensure that everything functions administratively in order to assist the board to carry out its functions.
When was the board established and why?
We're talking about a long time now. I believe my memory serves me right. It was just about 1944. Wow. It is a long time. Yes. And its main function is to try and balance the interrelationships between landlords and tenants. Okay. To ensure that they have a smooth functioning relationship. Any difficulty that arises, we try to deal with it in accordance with our statutory powers. And there are many of those, types of challenges. Yes.
What is the function and services of the Rent Assessment Board?
Okay. The board has the power to assess standard rent. In other words, if you're going to rent property, you need to make sure the property is registered. So the board has that registration function. And then, of course, you need to ensure that your property is being rented for the standard rent, the rent which has been approved by the board. So it has the function and duty to ensure that rent is assessed and to issue a certificate of assessed rent. Of course, during all of that, the property is going to be inspected, so there's that function as well. And all of that is concerned with getting to a reasonable rent, okay, called the standard rent. Now, it also has the duty to ensure that if there is an arrears of rent and someone, be it from whatever walk, a landlord in this situation is not being paid his or her rental, then that person can come to the board and ask the board to assist in recovering this arrears of rent, because, you know, tenants, they have rights, but they have obligations too, and they must pay rent. So the board has that function. The board also has the function of assisting tenants to recover rent overpaid. So that's the corollary of the first situation. That's the balance. Right. And there are many others, you know.
So let me see if I have it correct now. Is there a difference between the role and the function of the Rent Assessment Board and the Rent Services Unit?
No, because the Rent Services Unit is not a unit which exists separate and apart from the board. The Rent Services Unit provides the administrative assistance that the board requires and falls directly under the board and is answerable to the board. And the Rent Services Unit, as it were, is not a statutory unit recognized by the Rent Restriction Act, but it was created in order to have a name for the various persons who serve, right, that secretariat body who serve the policing of the act, so to speak, you know.
If I were, say, having a problem with my landlord or my tenant, why should I go to the rent assessment unit, and how could the organization help me?
If you're having a problem with your landlord or tenant, why should you go? Well, I suspect you would want to go because you want to get some redress, some remedy for whatever wrong it is that you feel that you have been afflicted by. And of course, you could go to the court too. But because the court system is inundated with a host of other matters outside of rental matters, then it might very well be more economic for you, less time consuming if you should come to the rent board, which is set up to deal with just that, rent issues in particular. So it's a special court, if you like, and people should really take advantage of that opportunity. Yes.
Now, members of the public not knowing about the rent assessment board may go directly to the courts for redress. Is this okay to do?
Oh, that's perfectly fine.
Okay,
that's perfectly fine. It is.
But they just need to know that this is the place that you go for your rental situation.
Because it is a specialized, yes, it is a specialized tribunal to deal with rental issues, yes, rental situations in particular, right. And of course, speed and economy is really, and less formalities.
Are all cases handled, and what are the ones that cannot be handled?
All cases that we are authorized under the legislation to handle are handled. What are we not allowed to do? Presently, yes, presently, the matter of recovery of possession does not fall under our mandate. There is move afoot to have the proposed amended legislation correct that situation so that that being one of the most critical areas where people need assistance from time to time, that could come under the jurisdiction of the rent board. The matter of harassment of tenants, that's a criminal matter. And of course, we are not a criminal tribunal. That is for regular courts. So the police must deal with that situation. Very often we get complaints that people, tenants, more often than landlords, go to the police station, they complain of harassment, they complain of being locked out, they complain of various types of abuses which are not permitted by the legislation, and the police do nothing about it. But we want to remind people that harassment is not tolerated under the legislation, and it is a criminal offense.
Okay, so you're saying that in a situation where the person is being harassed, they can also take their grievances here or report it to the police. Which one?
All right. It is a criminal matter, so properly speaking, you should go to the police. Okay. But because very often people don't know, and it is a rental issue, you come to the board with that complaint. And then, of course, we advise them what to do. You are to go to the police station. Sometimes we give them, most often, we give them a letter to indicate to the police what it is that we have had complained to us and to remind them of their duties under the Rent Restriction Act. We have been having a challenge in that department because, and I think we have to take it up elsewhere, but they resist sometimes. They feel that the rent board should be dealing with that issue, but it is really a police matter.
But you give them a letter?
Oh, yes.
And then should they come first to get the letter?
They don't have to.
They don't have
no.
to. They can go directly to
Directly to, it is a straight police matter.
Criminal.
Straight criminal proceedings.
Okay.
Now, I must ask you this question. Although the Rent Assessment Board does not deal with issues concerning recovery of possession of premises, we encountered members of the public who found themselves in situations in which the landlord seized their possession and changed the locks on the door. Now, what should this person do? Did the landlord have a right to do this? And how can he or she go about recovering his or her belongings?
Oh, not at all. This forceful eviction type of thing? No. That went out with the new act,
Okay.
or with the act in 1944. the Rent Restriction Act. Recovery of possession is dealt with by the courts directly. That is where you should go. If you're uncertain and you need advice, then of course we can provide you with that advice. But currently we have no jurisdiction to take on matters concerning recovery of possession. The most we can do is advise persons of their rights. It should go directly to the court system.
We want to emphasize that this is not legal.
What is not legal?
Like locking the person out.
Oh, not at all. This forceful eviction type of thing? No. That went out with the new act.
Okay.
Or with the act in 1944, the Rent Restriction Act.
What we want to find out, you see, Mrs. Taylor, right, about the rights of a tenant.
Yes.
We know that they have rights. And what are some of those rights?
Okay.
We know they have several rights.
A
but,
host.
What could we zero in on some
Critical
right
ones.
issues?
All right. When you think of the landlord and tenant relationships, you want to look immediately as to what are the most fundamental of rights which are created and exist alongside obligations. Now, landlord and tenant, you move into property. You want to ensure that you have sole, exclusive, and peaceful possession of those properties, of the premises you rent. And so that's a critical right. So the unlawful harassment is a violation of peaceful occupation. So the tenant has a right to peacefully occupy the premises he has rented, and the corollary, the counter to that is that you must pay your rent as a tenant. Right? So that's a right. That's the responsibility. It's the obligation. Now, another right. You have a right to make sure that, or you have a right to expect that the landlord provides you with habitable accommodation. So you don't just get up and rent any old place. There must be some minimum standards so that the purpose for which you are renting the premises is complied with. Okay? It must be fit for the purpose for which you intend to use it. You have a right to be notified of rental increase. Okay? A 7-day notice is important. You have a right to ask your landlord for the certificate of assessed rent. And in that regard, you also have a right to ensure that, or to expect that you are paying a fair rent, a rent which is assessed by the Rent Assessment Board.
Right.
Okay? You have a right to be given notice if the landlord wants you out of the premises. And usually that is aligned in law to the type of tenancy that you have. If it's a monthly tenancy, then it's a 30-day. If it's a weekly, it's a weekly. You know, if it's a bi-weekly, etc., it's a yearly. And that can be set in terms of the contract that you have. But you have a right to be given notice in writing.
Okay.
Yes, to quit, that is.
There
yes.
is this popular belief that if a landlord gives his or her tenant notice, that if you do not find a place in time, or you cannot find a place, you can get some time, some leeway, until you get a place to move out.
All right. I don't know that that is strict under the Act. In fact, it is not. But there is always communication between the landlord and the tenant, and then it is important in that regard for the tenant to communicate to the landlord and to see if some leeway, can be obtained. However, if you want more time and you have gotten a notice and you are taken to court for recovery of possession, you can always ask the judge to extend his or her discretion to you and to allow you some time. That happens in practice.
Okay.
Right? But it is not that you are not expected to get out of the landlord's premises when the notice expires. Right? Because if he gives you a notice,
on the street,
yes,
he won't be kicking you out
yes,
on the street. That's
no,
not allowed.
that is not allowed at all. Even although the notice expires, the landlord must still take out proceedings in the court if the tenant does not remove, because the tenancy is a statutory tenancy and it is governed by the provisions of the Act. So therefore, the Rent Restriction Act chips in, and the action for recovery of possession must take place, and of course the landlord must show that it is justifiable in all the circumstances of the case and that there is the balance of hardship type of thing comes in there. Yes.
Okay, what every smart landlord should know about his rights and the rights of a tenant.
But the critical ones, that he must try to get his premises registered and charge a rent that is set by the board. He must make sure that the premises are, sanitary. He must comply with the various payment of rates and taxes that he must, is required to do. That he must ensure that he gives notice to the tenant if he wants the tenant out, that he does not create any harassment and deviate from the peaceful occupation rule, that he gives sole and exclusive possession, that sort of thing.
If I want to rent my place,
Sorry.
what are the procedures involved?
All right. First of all, you need to register with the rent board. Because premises are all controlled unless you have been exempt, right, under the Act. Now, once you're registered, you need to apply to have the premises assessed so that the standard rent is determined and you know what the rent should be. And once you have done that, you enter into a contract with your tenant. It's strictly, it is not required that you do it in writing, but of course it is recommended, because all the terms and conditions that you both have agreed on will be in black and white. And once you have done that, I think the stage is set for you to move into a healthy landlord and tenant relationship. You would provide the do's and the don'ts into your agreements.
Is it right to charge months in advance on entry? And what is a reasonable charge?
Okay. It is not right to charge months in advance on an entry if it is a penalty or if it is a payment like a premium above the rental. But it is reasonable and not unlawful to charge what is a type of insurance, what we normally call the security deposit, which, as I've used the word insurance against unpaid rent, insurance against damage to your premises, insurance against unpaid utilities, water, light, cable, etc., that you tenants sometimes incur and leave the property, not paying. It has to be a bona fide deposit. And this is, something developed out of the case law. It's not actually dealt with in the legislation. There is move afoot to deal with that in the proposed amended legislation. So you ask me what is fair. That is not cut and dried. And one has to look at a number of factors. The courts have looked at a number of factors. The length of the tenancy, the amount of the deposit, what is to be used for, etc., to determine whether it is a bona fide security deposit. People can use their discretion and their conscience to arrive at what is fair and reasonable in the circumstances. I myself always say that the standard, the industry standard, what is usual, which is the 1 month for unfurnished, the 2 months for furnished, are reasonable.
That's reasonable.
Yes, I think that's reasonable.
Can a landlord sue for rent?
Oh, yes.
Can go to the courts.
Yes. Yes, and as we said earlier, you can also come to the board.
Okay, that's the better place to come.
Not that it is better, but it might be faster. Yes. So there is a dual jurisdiction there.
Mrs. Taylorite, there were some members of the public who had their concerns. Could you assist them by giving them some advice right here, right now, from the Rent Assessment Board? Let's take a look.
When I rented my house, I never thought it was fair to take a deposit. Now that I've given my tenant notice, how do I get him to pay for the damages that has been done to my property before he vacates?
Wow. You can try talking to him. I don't know if that's going to help. And can I say it? Next time, try to have that deposit in place and have a rental agreement. But that not being the case, please try to take out this action before in court to recover for the damage that you have suffered.
Shouldn't a tenant get the keys for the premises that they rent? And is it okay that a landlord can go into your room and sleep anytime them like?
There is a principle in law. A landlord cannot, should not derogate from the grant You grant the tenancy, you grant in law peaceful occupation, exclusive possession. All of what you have said derogates from those rights that the tenant should have. And of course, what it means is that the landlord is not fulfilling his obligations under the tenancy because he is preventing the tenant from enjoying the tenancy and the incidents of the tenancy. So I don't understand. He's taking back what he has given. He's not given exclusive possession. He's using the property jointly with the tenant, or maybe more, you know. So that is totally wrong. Totally wrong.
Is cooler. She needs to, her room is cooler, and her room seems to be hot. So she goes and hangs out there. That's a real situation.
No, she would have to get the consent of the tenant. And clearly the tenant isn't consenting in this situation.
Or he would not be complaining.
Or he would not be complaining, you know. And key? What do you mean? If she shouldn't get a key? Is that he? If the tenant shouldn't get a key? Something is wrong with that. The tenant is obliged. If the tenant is obliged, let me finish my sentence. The tenant is obliged to get the key. The key indicates that you have been given possession of the property. It sounds to me as if the tenancy has not even started. It sounds like a license with a lot of conditions, because unless you have possession to the place that you have rented, then you shouldn't be paying rent for it. You know, there needs to be some serious discussion about that.
My landlord said that next month I'm going to raise my rent by $1,500. Can he do that one time?
It would have been good if we knew what the rent was before, because we are not able to assess whether this is the standard 7.5%, which is statutorily acceptable. You see? But if it is above the 7.5%, and clearly this is not agreed, and you can't really contract out of the act in that way, then the tenant needs to come to the rent board and make a complaint so that that matter can be addressed and the property inspected to see if the rent is appropriate.
I have given my landlord notice. She has a deposit for me. Could I leave it out?
You're not supposed to. If the landlord agrees, then I suppose you can. But you can't just take it upon yourself to say, I'm going to leave out the deposit, because then the purpose of the security deposit would be defeated. And that landlord would have charged a security deposit to provide, as we have said, as a type of insurance against various things, unpaid rents, damage to property, etc., unpaid utilities, you know. And so you shouldn't really leave it out unless you have the consent of the landlord.
Mrs. Taylor-Wright, you have been very helpful today. And I'm sure members of the public, whether you be a landlord or a tenant, should be able to use this information for their benefit. How has the Rent Assessment Board been helping you so far? Has it been of any help?
Certainly. They've provided me with valuable information that ordinarily I would not have had that information. And I say to all persons who require the assistance of the rent board, whether you're a tenant or a landlord, to come here to seek some information and advice.
Thank you so very much.
Oh, you're welcome.
So no more problems with your landlord or tenant? Ah, if that were so. But you now know where to go to get your justice.